Hello, everyone. Welcome to the day 11 of the cyber awareness campaign named Cyber Vakeel. A 30-day cyber awareness campaign led to gain knowledge on cyber crimes and various cyber laws in and outside the country. Today, we are having a discussion on Indian versus international laws, and we are having amazing speakers today. Mr. Abhinav K. Mishra, who is a researcher fellow IIP Tokyo for blockchain patents, partner LexPlex, and a visiting faculty of Indian Law Institute. Now, I would like to invite our co-speaker also, Ms. Sonal Saxena ji, Head Research and Innovation Division, My Lawman, partner LexPlex. Thank you so much, Sonal ji and Abhinav ji, for accepting our invitation and joining us on this amazing discussion today on Indian versus international laws. Now,
Thank you so
without any
much.
delay, I would like you to please continue the session. Over to you.
Thank you, Mr. Mittal, for such a wonderful opportunity. And at the same time, I would like to congratulate Cyber Jagrithi for conducting this 30 days awareness program, which is one of its own kind program in India, covering up the diverse issues of the cyber space world, cyber laws, etc., for a 30 days program to create awareness among the people. So it's a very wonderful initiative to which I hail, and I guess that people should be enjoying and getting benefit of it. So congratulations and thank you for bringing us to this webinar of today, which is on cyber laws. We will be dealing with the Indian and international approaches to the cyber laws. I would be speaking alongside my co-speaker of the day, Ms. Sonal Saxena, Head Research and Innovation Division, my lawman, and partner LexFlex. So we actually would be dealing with various aspects of the cyber law, the Indian cyber laws, the US cyber laws, UK cyber laws, GDPR of in Europe. And at the same time, I would be dealing with five different peculiar points um, in Indian law, which would be dealt from the practical orientation, yes, a practical perspective, would be very helpful for the engineers, lawyers, and common man as well. So let's begin our webinar. Um, so the approach of this webinar would be at first the conceptual understanding, later on which would go towards the practical considerations of the considerata which would be taken out from the Indian laws and then would be compared by both of us here. The method would be explanatory, of course. Discussion would be done on the basis of the questions asked, which would be dealt, I guess, by the moderator of the day, Mr. Mittal. And I would divide my introduction, our presentation into the three parts. The first one would be the conceptual introduction. Second one would be about this dealing with the Indian and international approach to the cyber laws. And third would be 5 point some things. In the last point of the 5 point something, I would deal with the five different peculiar features of the Indian cyber laws, onto which sometime I would show you a different good things of the Indian cyber law, or sometimes I would point out some things which are to be changed or which needs reconsideration by the Indian, Parliament or the Indian authorities. So moving ahead with the conceptual clarity, since the whole program, the whole, not only this webinar, but the whole 30 days by this Cyber Jagrithi has been about the cyberspace, I thought that why not let's reconsider the idea of cyberspace when we are talking about the cyber laws in particular. And we are dealing with the cyber laws of the India and the international areas. So the internet today, the cyberspace on which the whole concept is based, could be said to be or it has taken the shape of the parallel universe, just like the multiverse of the DC Comics and the other comics of um, foreign US. So the network computers here have created such a virtual life for the people that people now take rest from the real life and go to this virtual life to create their another to get the benefit of the another virtual life. So it has created a kind of web universe. The web universe, of course, was a virtual concept which was focusing on the virtuality and using the virtuality of the cyberspace. But today, this idea has grown so much. This idea has imbibed into our life so much that it's not just a comic concept of the parallel universe or the multiverse. It has become our day-to-day life. You would see that the the amount of use of internet, digital technologies, computers and smartphones in my minute to minute daily life has put us into such a situation wherein we are bound, knowingly or unknowingly, by the rules of the same virtual cyberspace, and which have the impact onto the real world. And therefore, there is a need to have a robust legal system of cyberspace which would govern the cyberspace so that we could mitigate the negative impacts which are coming on to our real life. From digital life, what we are perceiving and getting the impact onto the real life of the people, that could be mitigated, and the concept would be regulated or should be regulated by using the multiple laws, or maybe even one robust. What the society is wanting today is one robust law onto the cyberspace. However, this has not been that much successful because India has only one IT law, but still lacking behind, whereas the US has the multiple laws, but so many multiple laws are creating again problem. And UK, using its some written, some unwritten rule policy, they also have very less laws, only 2 3 acts are there, but still they are doing it well onto the part of the enforcement and all. So I would move to the next slide, where we would develop our concept of the web universe, that what is the base of the web universe. What do you think? This question I would like to pose to my audience: that is the base of the web universe? What do you think is the base of our web universe? This cyberspace, this virtual world, this internet, this digital life, this digital technology, virtual life. Second space, although second space is a website, and they have the same concept, but I would like to point that here, where you get the second life. What do you think that it is based on? It's all based on to one thing only, which is data. The data could be related to now the personal life, wherein you can see that the people are, or the young minds are now emerging more into the social media. People are flaunting their personal lives there. So this one thing is there. और उसके बाद में the second thing, data related to your corporate world, your business world, sensitive information, and other related information, wherein it could be about the relativism, it could be affecting your public private life, and otherwise. So when we are dealing with the data, there could be two concepts of it. Either we would be focusing on the data being just merely the information, or if one person is very sensitive, they could also think it as being another life, as having the impact or which could have the impact onto the real life. So उस चीज के लिए what is necessary, that you should keep in mind that this web universe has now expanded. The idea has taken shape into the real life. The effect and impact does come to the real life, but it's all depend on the data. Wherever it is necessary to share data, you should. Wherever the data should or is regulated by the law, you should do the same or the otherwise. So because of the same web universe, because of the same idea onto which I was making your conception of the web universe, the business of cybercrime has taken shape because of its features of being like people being anonymous, the anonymity feature, easy to use. When the people have a bit of the knowledge of computer development, program development, they could use it. And even today, तो ऐसा हो गया that we have the advanced level softwares which could be used by any person who does not even have the good knowledge of the computer coding or the computer programming, but they can use different softwares which are very easy to use nowadays. The very basic example could be um, you know the advanced level Photoshop softwares and video editing softwares, wherein people change the face of the other and use it as a revenge porn otherwise. This could be one example. The business of cybercrime is also flourishing because they get a bigger target. The large target groups are there, and therefore it has also become the eye candy for the terrorists. A new section in the cybercrime has emerged, which is called as the cyber terrorism, which is because of it only that the terrorists are anonymous. This computer savvy, tech savvy things are easy to use. They can use it from the far off places, and they can target large groups. Then there can be the multiple modes to use it. It's not that only one mode could be used. You might be getting in your email box request for the money transferring, request for the that they would give you money, or you have won the jackpots, etc., kind of luring schemes which lure you to click onto the links, and then they do their work. Or there would be certain websites which would be telling you that you need to change your password, etc. So there are multiple modes. It could be a complex cracking using the computer programming language. It could be the email spamming, or it could be the email or the different data bombing, or it could be the denial of service, DDoS. So different and multiple modes of the cyber crimes are there, by which it also has grown up and taken place. And the many tools, the different tools to do these kind of cybercrime, to commit these kind of cybercrime to a large target group, have made it eye candy for the criminals today. And therefore, the all those tactics, which I have a few of them I have mentioned: the hacking, cracking, spamming, phishing, identity theft, denial of service or distributed denial of service, DDoS. Of course, certain other real world problems has taken shape into the cyber world, like pornography has become now cyber pornography, stalking has become now cyber stalking, and terrorism has taken shape as cyber terrorism, which I mentioned earlier. Even. So looking at these many type, mode, and tools of the cybercrime, the use of a specific criminal law was very important and necessary, very, very pertinent. And therefore, it was not only in the 20 this century, but even in the last century, in the 1970s something, the cyber criminals, or I should say that computer criminals, were even being prosecuted under the wire criminal law of the US government. So this thing started way back in 1970s, 1980s, wherein the phone freaks, the wire freaks, used to commit hacking and cracking, freaking, freaking, uh, different activities onto the wire modes. When the computer came, they used to change the computer codes and data theft, etc. By those small hacking, it has taken shape of the today's organized, distributed denial of service, organized DDoS to the cyber terrorism. We have come a long way. We have crossed a long road, but still, this police thief game is going on, and we are still chasing the hackers again. What need today is a simple understanding, which is expected not only from the police, which means that the law enforcement agencies, judges, but also from the common people. Because the target group are the people, the law enforcement agencies involve themselves, but most of them freak out that how they would be able to deal with the cyber situations. And solution to that simple problem is a simple understanding. The simple understanding of devices, of people, of gesture. Law is specific to the words, but even if you would find different words in the different countries with reference to the cyber laws, there may be many act model as the US has adopted, maybe one simple code model as the India has adopted, or middleman approach as the UK has adopted, having two, three different laws and certain other unwritten laws. In all those kind of approaches, you would find out one thing, that all these laws of cybercrime and cyberspace address to one common consensus, that what is considered to be crime onto this virtual cyberspace, the virtual society. The wrong would be wrong, and wrong would be dealt by the law, making it a crime, therefore cybercrime. Yes, the punishment may differ in different countries. And this simple understanding would lead them to save themselves from the cyber criminals and make their life a better place to live in virtual world as well. But let's now move on to the next point, which would be dealt by my um, speaker. She would deal with cyber law and different types of the cyber law and the approaches in India, UK, and US. Ms. Sonal, please.
Thank you so much. So, good evening, everyone. So, let us have a look at what is cyber law. What do you basically understand by cyber law? So, cyber laws are basically those laws which are governing your cyberspace. And what is your cyberspace? Your cyberspace basically it includes your computers, your networks, your softwares, your data storage devices like your hard disk, your USB drives. Then you have your internet, which is again the biggest part of cyber world, cyberspace that we have. Your websites, your emails, even your cell phones and your ATM machine. They are a part of cyberspace. So coming on to what does your cyber law basically deal with? So cyber law it basically deals with the cyber crimes, the electronic or your digital signatures, the intellectual property, data protection and your privacy. So can I have the next slide? So coming on to what is cybercrime. As you can see here, there are four different types of cybercrimes which I have mentioned. The first one is against a person, the second is against their property, the third one being against the government, and then there are some other cyber crimes. So I'll deal with them one by one. First one is your against the person. So a cybercrime against the person, it includes things like what you call cyber stalking, your impersonation, your loss of privacy, transmission of obscene material, harassment with the use of computer. Then against the property, you have your unauthorized computer trespassing, including computer vandalism, transmission of your harmful programs, stealing secret information and data, and copyrights. Then against the government, your cybercrimes include hacking the websites of the government, which is pretty frequent, as you would have seen. Then you have your cyber extortion, your cyber terrorism, and computer viruses. Coming on to the category of some other cyber crimes, the first one is logic bombs. Now, what do you basically understand by logic bombs? So, logic bombs are basically codes which are intentionally inserted into a software system by people with the malicious intention. Basically, the function of logic bombs is to basically have, for example, I'll explain this in form of an example. For example, there's a programmer in a company and he inserts a piece of code in the files that he has, that in case if he is terminated or if his data or his profile is being removed, that code will auto activate and it will delete all the files on the machine. So that is called a logic bomb basically. Okay. Then you have your viruses, worms, and Trojan horse. Then you have email bombing, spamming, and email abuse. These are your other forms of crimes, the cyber crimes. Now, next, let us move on to cyber laws in India, US, and UK. Can I have the next slide? I can't hear you, you're muted.
Now, am I audible?
Yeah, you're audible now.
Okay. So there is one another kind of, yeah, like you can say that there are certain cyber crimes which has now taken place into this cyberspace world, and we do not know the way to put them, or they could be said to be a new species of cybercrime, like cyber murder. Like it happened. There is a famous case in US. Uh, they happened so that the husband, had the access to the wife's Facebook ID, and after they got separated through a divorce, the husband deleted the profile of wife, and it was termed as cyber murder by the court, and he was charged, of course, with certain cybercrime against the property, and which is categorized here under. But this could also be said to be a cybercrime against the persons, as the personal profile of that lady whose profile got deleted was involved therein. So these kind of overlapping crimes and overlapping categories of cybercrime and the new cybercrimes could also define these eras. So yes, I won't take much of time. Please
No,
continue,
that's
Sonal.
fine. Yeah. So let us now have a broad overview of the different cyber laws in India, US, and UK. In India, basically, you have the IT Act, the Indian Penal Code, and the rules with regard to the IT Act 2000. Okay. So first of all, India does not have a dedicated cybersecurity law. Basically, we have different laws which are in combination dealing with cybersecurity as cybersecurity law. Okay. So first you have your Information Technology Act, which is the IT Act, which is read along with various rules and regulations which are framed under it. Those rules and regulations are basically dealing with cybersecurity and the cyber crimes. So your IT Act, along with providing legal recognition and protection for the online transactions which are carried out via electronic data interchange and by other means of electronic communication. It also contains provisions which are mainly aimed at safeguarding your electronic data, your information or the records, and preventing the unauthorized or the unlawful use of a computer system. So there are some cybersecurity crimes that are specifically envisaged and are punishable under the IT Act, which are like hacking, denial of service attacks, phishing, malware attacks, identity fraud, and electronic theft. So let us now move on to the rules and regulations which are framed under the IT Act. So the first one is your CERT rules, CERT rules, which is Information Technology, Indian Computer Emergency Response Team and Manner of Performing Functions and Duties, Rules 2013. So basically, under this, what you have is a nodal agency which has been set up. The name of the agency is Computer Emergency Response Team, which is also known as CERT-in, which is CERT in India. N is for India. Okay, so this nodal agency is basically responsible for three things. First is your collection, second is your analysis, and third is your dissemination of information on cyber incidents. All right, and this also takes heed of emergency measures to contain such incidents which are happening. The second rule which you have under the with regard to your Information Technology Act are the SPDI rules. SPDI stands for Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules, 2011. These rules, what they do is basically they prescribe your reasonable security practices and procedures which are to be implemented for the purpose of collection and processing of personal or sensitive personal data. All right. So the next in line is your protected system rules, which is Information Technology, Information Security Practices and Procedure for Protected System Rules of 2018. Right. Under these rules, what basically happens is like they require specific information security measures to be used and implemented by the organizations that have protected systems. All right. The fourth rule, which rule set of rules which we have under the Information Technology Act, is your Intermediate Guidelines Rules of 2011, which basically they require intermediaries to implement reasonable security practices and the procedures for the same, including for securing the computer resources, right, and the information which are contained in those systems. These intermediaries, they basically also require to report cybersecurity incidents to CERT, which is a nodal agency which was set under the CERT rules 2013. All right. Next, we move on to the USA legislations, the cyber laws in the United States. So, as I have listed here, we have the Computer Fraud and Abuse Act (CFAA). Then we have Cybersecurity Information Sharing Act of 2015. Then Cybersecurity Enhancement Act of 2014, and Graham-Leach-Bliley Act of 1999, and the Health Insurance Portability and Accountability, which is HIPAA, which is mentioned at the end. So the one which is mentioned in the end, which is HIPAA, HIPAA, it is basically particularly for the healthcare sector only. The one above it, which is Graham-Leach-Bliley Act of 1999, that is particularly for the financial sector. So US has laws which are particularly for healthcare sector also and for financial sector also, the cyber laws, right? Again, US does not have a unified set of regulations which are covering all the sector of the economy. The reason you see, you have healthcare and financial sector laws which are being made separately. Instead, they basically have a combination of federal and your state rules which govern cybersecurity. Uh, this, although it makes compliance difficult, but it distributes it between different sectors, right? So, two important legislations which United States has is Cybersecurity Information Sharing Act of 2015 and the Cybersecurity Enhancement Act of 2014, CEA. So, your Cybersecurity Enhancement Act of 2014 was basically designed to support the development of voluntary and industry-led procedures so as to reduce the cyber risk to the critical infrastructure, right? The next, which we have CISA, which I mentioned, is Cybersecurity Information Sharing Act of 2015, has set the basis basically for voluntary information sharing between the private and the public sector. So this gives way to sharing information on a voluntary basis, right? It grants companies to basically have confidentiality and immunity from civil and criminal penalties also when they share information regarding cyber threat with the Department of Homeland Security. Okay. Next, stringent data protection and breach notification rules, which have been set for the financial sector and the healthcare sector, as I already mentioned. Your Graham Leach Bailey Act of 1999 and the Healthcare Insurance Portability and Accountability Act, which is HIPAA. All right. Next, we have your UK legislations. So the main legislation which United Kingdom, or you could say Europe, has, United Kingdom in particular has, is Computer Misuse Act of 1990. Okay, so this is the main UK legislation which relates to the offenses or the attacks against your computer systems, such as like hacking or denial of service, which is DOS attack, basically, right? So CMA, it deliberately, one thing it does not do is to define which is what is meant by a computer. Okay, because this gives it a broader perspective to allow for technological development, as we say. All right, so here we have a case, DPP versus McCohen and DPP versus Jones of 1997, which basically it defined computer as a device for storing, processing, and retrieving your information. This means that a mobile smartphone or a personal tablet device could also be defined as a computer in the same way as traditional desktop or PC or laptops that you use, right? So your computer does not necessarily mean just your laptop or your PC that you're using. Your tablet and your smartphones are also a part of the terminology computer under the purpose under the CMA Act that you have in UK. CMA again is the Computer Misuse Act of 1990. Okay. Next, if we have a look at the entire region, Europe, right? So each country within European Union is basically supposed to operate under one common foreign and security policy, which they call as CFSP. And there are various directives also which require each state to basically take relevant security measures, right? So there's one, this directive, NIS directive 2016/1148, which basically requires each member state to impose security and notification obligations, all right, on their nation's essential services, service provider, both public and private. So this directive, it governs not just the public sector or the private sector, it governs both the sectors simultaneously. And it also introduces penalties for the failure in case you do not comply by the rules of the directive. Uh, it also has the penalties mentioned for the same. Okay. Another thing is European Union has also implemented through your data protection regulation, which directly crosses into the matters of cybersecurity. With the General Data Protection Regulation, the GDPR, based on which, okay, one fact over here is based on GDPR only, the recent data protection bill that we have in India is heavily based on GDPR. Okay, so the GDPR, which is the General Data Protection and Regulation Act in Europe. Okay, the regulators have basically created a set of data protection and privacy rules that have been embedded in the European Union law. Okay, they apply basically to every company which is dealing with European Union citizens' data, and compliance is mandatory for all the firms. Okay, located even outside the European Union if they're dealing with the European Union citizens. Okay. In case over here a breach occurs, the question of the blame, you could call it, largely it hinges on whether the company was negligent by basically ignoring the basic practices that could have prevented such a breach. Okay, so I guess I could just take up the data protection bill in India. Now, can we have the next slide? Would you like to add something? You're muted.
India. Okay, sorry.
Uh-huh.
Now, am I audible?
Yeah, yeah.
Am I audible? Okay.
Yes.
So the only thing I wanted to focus a bit, like for the conceptual clarity, that the development of laws, the cyber laws in India, US, and UK have been very different. The India has taken a step of implementing, yeah, for, bringing in the Information Technology Act in 2000 after the ancestral model law, wherein the countries came on to the consensus of creating a network or the frame, sorry, not network, but the framework for the e-governance practices and legitimizing the e-practices and signatures and also e-documents. So for that purpose, they created Information Technology Act, which is based on to the e-commerce law. And then later on, or I should say that in the same act, the cyber crimes were added, since the cyber crimes are particularly done upon the same e-commerce or to the computer practices. But in US and UK, it was from the criminal angle. From the very beginning, they had the different computer fraud and abuse act, when you can find out that computer misuse act of 1919. And I also mentioned that US first started prosecuting the computer criminals under the Wire uh, Act, Wire Fraud Act of in 1980s something. So we could just see that the angle in US and UK was to prosecute the criminals who are involved into the such criminal activities into the cyberspace. Wherein in India, we adopted this from the angle of wherein the international standards were being framed up onto a certain standard of providing the e-commerce practices. So that is one thing. That is the reason you would find out that US and UK have the different laws, wherein India has only one code, the Information Technology Act. And Information Technology Act is comprising of the different, set of laws. It is a comprehensive code combining the administrative law portion, combining the criminal law portion, combining the e-commerce commercial law portion, and contractual obligations, and also the set of rules and the procedures how the functions should deal with. And earlier, this PPT also mentioned that the part of the cyber law I would focus here comprises of, in the end it's written, internet governance. So the IT Act governs with the internet governance as well, a bit of it, not the most of it, because the internet is considered to be open and free. E-commerce, I said that our IT Act is dealing with the e-commerce laws. Data protection and privacy, though we do not have the comprehensive code, but yes, the data protection is there in India, and privacy laws are also there. But howsoever flawed the definition may be, which I will deal in the later part, but the data protection and privacy concept have been added into the Information Technology Act. Cybercrime, the again Cybercrime Act sections are there, and cyber warfare and terrorism, which is a part of the cybercrime, have been dealt with. Now, cyber warfare and terrorism could also be said to be the part of the cyber security initiatives which have been taken up very recently in the Act, Cybersecurity Information Sharing Act of 2015 in USA, and Cybersecurity Enhancement of the 2014. And also in UK, the cybersecurity new laws are coming up. So these all sections you would find out in USA have been given in the different acts. No comprehensive code could be found out. In India, there is one comprehensive code, although we are lacking behind and we are trying to come up. जैसे कि for example, for privacy, we are coming up with the new law. And in UK, we already have the different laws. For cybercrime, Computer Misuse Act is already there. For cybersecurity, a new law is coming. Serious crimes has included the cyber terrorism and other acts by way of amendment to the CMA only. And GDPR has been added like by way of Data Protection Act of 2018. So you will find out the different legislation, but not so many legislation, and most of them will also go on unwritten values. So, okay. Thank you. You can go on further.
Okay. So next is your data protection bill. So let me give a little bit of a background about the data protection bill before we move on. It basically reads Data Protection Bill 2019. But this bill basically, first when it came up, it was in July 2017 by your Ministry of Electronics and Information Technology, which constituted a committee of experts basically under the chairmanship of your retired Supreme Court Judge, Justice B.N. Sri Krishna. And this committee was basically entrusted with the responsibility of identifying the lapses in the present data protection regulation and preparing a more robust and a comprehensive data protection laws in for India, right? So, after working for nearly 1 year, the committee submitted the draft Personal Data Protection Bill in 2018. This was in July 2018 that the post submitted it. So, since its introduction last year, MIT has basically solicited comments and suggestions on the bill from the public and various stakeholders, your ministers, and the consultants. So, based on these suggestions, we have a revised personal data protection bill, the draft bill, which is 2019. So this was cleared by the Union Cabinet on December 2011. However, uh, now this is with the Standing Committee, and the Standing Committee has taken an extension up to the winter session, the second week of winter session. So let's see. We hope this would turn into an act this year, or else probably in the first half of the next year. So okay. Now talking about the bill, there are different areas of the bill I'll be discussing with you. So we have applicability, the obligations of data fiduciary. I'll be talking about who's a data fiduciary and what are the obligations. Then we'll be talking about the right of the individual, the grounds for processing the personal data. Then what would be the social media intermediaries which are mentioned in the bill. Then your data protection authority. Then the transfer of data outside India, right? Then the exemptions which I mentioned, the offenses and sharing of non-personal data with the government. Okay, and what amendments would it bring to the other laws, specifically your IT Act 2000? So first, let us talk about the applicability of the bill, which the applicability it extends to whole of the India. So the bill it basically governs the processing of personal data by number one, the government, number two, the companies which are incorporated in India, and number three are the foreign companies which are dealing with the personal data of the individuals in India. So, what do you understand by personal data? So, personal data is basically your data which pertains to characteristics, your traits, attributes of identity, which can be used to basically identify an individual. Right. So this bill categorizes certain personal data as like sensitive personal data, which includes your financial data, your biometric, your caste, religion, or you can say your political beliefs and any other category of data which is specified by the government in consultation with the authorities and the concerned sectoral regulators. Right. So this is what the bill governs the processing how like bill governs the processing of personal data by basically again government companies incorporated in India and the foreign companies which deal with data of individuals in India, right? So next is the obligations of your data fiduciary. Now who is a data fiduciary? Basically, your data fiduciary is an entity or an individual who decides the means and the purpose of processing your personal data. Okay, so this entity or individual is basically called data fiduciary, right? So, the processing which will be taking place will be subject to certain purpose, collection, and storage limitations. For instance, your personal data can be processed only for like specific, clear, and lawful purposes. Additionally, all the data fiduciaries they must undertake certain transparency and accountability measures, right, to keep the process smooth and transparent. So there are certain measures which are being prescribed by the bill, which are like number one is your implementing security safeguards such as your data encryption and prevention of misuse data. Then second is your instituting grievance redressal mechanisms to basically address the complaints of the individuals, right? So they must also institute mechanisms for age verification and parental consent when processing sensitive personal data of children. All right. Next is the rights of the individual under the bill as mentioned. So the bill basically sets out certain rights, which include number one is the right to obtain confirmation from fiduciary on whether their personal data has been processed. Number two is seek correction of for inaccurate, incomplete, or out of date personal data. Third is you have a personal data transfer to any other fiduciary in certain circumstances. Fourth is restricting continuing disclosure of their personal data by the fiduciary if it is no longer necessary or if the consent is withdrawn. Right. So these are basically the rights of the individual, which are mentioned in your Data Protection Bill 2019. Coming on to the grounds for processing personal data. So, personal data, according to the bill, can only be processed if the fiduciaries give consent to it, to processing it. Okay? If the consent is provided by the individual, only then your personal data can be processed by the fiduciaries. However, there are certain circumstances definitely where the personal data can be processed even without the consent. Like, for example, you have your legal proceedings. You have to respond to a medical emergency. If it is required by the state for providing benefits to the individual, right? In such circumstances, the fiduciary will not need your consent. But in other circumstances, definitely the fiduciary will need the consent. Now, who are social media intermediaries? So, social media intermediaries, which basically enable your online interaction between users and they allow for sharing of information, right? So, bill basically is defining your social media intermediaries. All these intermediaries they basically have to have users above a notified threshold and whose actions can impact electoral democracy or public order. Okay. Next, you have your Data Protection Authority. Now, this is important. The bill is setting up a is basically sets up a Data Protection Authority, which can do the following. Number one is to take steps to protect the interest of the individual. Second is to prevent misuse of the personal data. Third is to ensure the compliance with the bill. So this data protection authority, it will consist of one chairperson, and then you will have six members with at least 10 years of expertise in the field of data protection and information technology. So the orders of the authority under this orders of the data protection authority, they can be appealed uh, in front of a tribunal, and the second appeal lies with the Supreme Court. So the now it is about the transfer of data outside India. So when they are dealing with the data which is sensitive, it is your personal data. So it can be transferred outside India for processing if you explicitly give consent to it and subject to certain additional conditions also. However, for the purpose of safeguarding your data, this personal data, should continue to be stored in India. But certain personal data can be notified as critical personal data by the government, which should like never go out. It can only and only be processed in India only. All right, then you have your exemptions. The central government, it can exempt any of its agencies from the provisions of the act if it is definitely in the interest of the security of the state, public order, sovereignty and integrity of India, and friendly relations with the foreign state. Second is for preventing incitement to commission of any cognizable offense. Now, processing of the personal data is also exempted from the bill for certain other purposes apart from these. Apart from these general purposes which are mentioned, the other purposes are prevention, investigation, or prosecution of any offense, Second is personal, domestic, or third is your journalistic purposes. Right. However, such processing it must be for specific, clear, and lawful purpose only, with certain security safeguards. Now, the offenses under the bill they basically include for like processing and transferring of personal data, which is in violation with the bill. It is punishable up to a fine of rupees 15 crores or 4% of the annual turnover of the fiduciary, whichever is higher. Right. Second is the failure to conduct a data audit, which is punishable with a fine of 5 crore rupees or 2% of annual turnover of the fiduciary, whichever is higher. All right. Coming on to the sharing of non-personal data with the government. The central government may direct the fiduciary to provide with any non-personal data or any anonymized personal data where it is not possible to identify the data principal for better targeting of the services. Okay. Now let us see what amendments to other laws does this bring. So basically, for the provisions relating to compensation which is payable by the companies for failure to protection of personal data, this bill basically seeks to amend the Information Technology Act to delete that provision. So basically, it seeks to delete the provisions relating to the compensation which is payable by the companies for failure of the protection of personal data. Okay, so this was your Data Protection Bill 2019, which is still to be made into a law. All right, so next I'll ask Abhinav to take over the lecture from you.
Thank you for such a comprehensive idea, such a of the bill, which
Thank
is
you.
to be made into the law. Actually, this Indian Data Protection Bill does not only solve the problem of the data protection or privacy, but also solve to many whole problems which you might have seen in certain cases. For example, I would start uh, the first problem of the you know keeping the data in India, the data localization. Second one, encryption technologies. India have the very old encryption regulation, which is still talks about the 32-bit technology, whereas we have reached to the encryption technology, or we generally use 256-bit of the encryption technology. And third one is about the privacy issue, which now have been solved in a constitutional manner by the Constitutional Court, the Supreme Court of India in Putraswamy case. But still, the law was not there to address any of the privacy problem. But insofar as the privacy is with reference to the data protection, this data protection will covers it very well. And also, it conforms to the international standard of the GDPR. That is the whole idea of the Data Protection Bill 2019. But I wonder so many times that why India could not address this needy problem of the data protection till yet. Because the PDP came in 2016, could not, even 2016 it came beforehand, but that bill could not even come to the floor of the legislature in Lok Sabha. Then second bill came that was in Lok Sabha, could not pass the Lok Sabha. Third bill came which could cross the Lok Sabha but could not go to the Rajya Sabha. And here this bill is there, which is still looking after the way to find out the space into the book of the statute. But let's see. We are hopeful that it gets to our statute book until next year, and that would be very nice of it to have the at least not only one data protection bill but different unvague definitions would be solved, and also one data protection authority would be made over wherein the complaints could be taken over. So, thank you for bringing up this topic, Sonal. Now I would deal about four points, like 5 point something. Wala. There was a movie 5 point someone. So The idea of that movie was that 5 pointers, the average sometime, have the greater impact. Similarly, I would deal with these four problems, and specifically, these four problems are different, flora of the law of cyberspace. Like the e-signature is from the e-commerce, cyber privacy is from the constitutional angle of the cyber privacy, intermediary liability is all about internet governance, and critical information infrastructure protection is about the cyber security. Like all, remember all those points which I mentioned, that one good cyberspace law should incorporate internet governance first. Second, I talked about the e-commerce, then cyber crime, then cyber security, and one more about the data protection. So I have kept all these four categories from them. So I think that I would be able to do justice by telling you some peculiar points about these four items. Dealing with the very first step, making e-signatures. So see, what about the e-signature? What is very specific about the e-signature in India? If anyone could guess, then we have like two types of signatures, or we can say that two different definitions covering up the idea of e-signatures in Indian IT Act 2000. The digital signature and the electronic signature. The digital signature was the first terminology, या फिर ये कहें that digital signature was the initial terminology which was present there in the IT Act 2000. The same terminology, digital signature, was used out of the ancestral model law, and it was referring to one particular kind of signature, one particular kind of technology which was based on public key infrastructure technology, PKI system, which PKI system incorporated, have two kinds of keys. One is the public key, the other one is the private key. Just like you can get that two keys are used in one block, which one is the public, anyone can use, and another one is private. You can understand these two key system, like the private key is your signature pen. You can signature by it. No one else can use your private key. But public key can view your signature. So anyone can view your signature, but anyone cannot write your signature. And if it is viewed by the public key that it is the same signature written by your private key pen, then the authentication is successful. The technology is much more complex than what I described. But I guess now you have understood from the idea of being public and private key, just like the writing pen and torch by which the signatures could be found out what a system. You can get the PKI infrastructure technology idea. So earlier, when the law came, the IT Act in 2000 came, it had only the digital signature PKI infrastructure, which meant one thing, that only PKI infrastructure based signatures or technology could be said to be the technology which was authenticated, rectified by the law. Not any other signature or the technology was taken up as the electronic signature. An e-document cannot be called to be an e-document if that is not authenticated by any digital signature. So earlier we did not use any such biometric. For example, at that point in time, the biometrics were not in, very much in picture. But yes, the technology was very much known to the people. But still, we had only the digital signature. Now today, this technology, the of using the biometrics is prevalent, is very much prevalent in common users. You might have seen the Aadhaar. The Aadhaar authentication starts from your taking up all the biometric data. So they needed a different change into the definition of digital signature. There were two ways to do that. One, either they could have edited, amended, updated the definition of the digital signature and added other secure means, but they added the different definition. They added another electronic signature meaning or terminology or definition which is based on any other secure means. Of course, there are certain considerations to look into. For example, that the electronic signature could be any other secure mean which is considered to be secure, or government has ratified it to be secure, or it is attributable to the person generating it even after. And when it is had, it could be attributable that it is not the same signature, just like the concept of the digital signature. But essentially हुआ क्या, that we got two different signatures, digital signature and electronic signature. So electronic signature is a broader idea, the genus of it, and digital signature is one idea, the species of it. Halanki, this is very peculiar that it happened so that first came the digital signature, the species, and then came the genus, which is very undigestible to digest, but this is the such law today. Now, electronic signature means any other secure means in technology which could be attributed to the electronic signature, and digital signature means PKI infrastructure based technology. I would just give you one example, and I hope you would be able to understand this complex situation here. If any mail system is there, email, would you call that e-document ratified by the electronic signature? So first you will have to find out that whether mail ID is attributable to the person. Yes, I am Abhinav Mishra and I have my mail ID abhinav@mylawman.co.in. Second, the access to the ID is attributable to me or is in the possession of me that time when the signature or the document was created. So when I created my mail, whether I had the password ID or username, yes, I had. So two checks are there now. Now, third check would be whether it uses the secure means. So when I create an email, whether that can be attributed to me. So very good companies like Google, Yahoo, Microsoft, and Lenovo and other good services use two-way authentication feature. This is not a two-factor authentication which you use on your mobile phone, but this is a two-way authentication feature by which the encryption is used at both of the ends, the sender and receiver, by which they can attribute that if any hacking in the middle have been done, this same secure message could not be obtained. So
Abhinav,
when
we are unable
any
to hear
mail
you.
service is using the same secure means, with maybe depending on PKI infrastructure or otherwise, जैसे कि Google uses the PKI infrastructure and some other mail company uses the other secure infrastructure means, that would be said to be electronically signed document. So my mail, if I have the username ID, if I have mail on my name, if this secure means it becomes a copy of the document. And therefore,
I think there is some network issue and he got disconnected. Sonal, can you continue?
I think he'll just join back because he's got stuff there. Just a second, hold on. Yeah.
saying that connection was dropped. So now, am I visible and audible clearly?
Yeah.
Okay, thank you. So now I was dealing with the problem of the electronic versus digital signature, wherein I was taking up the example of email. So a secure, using a secure security practice, any mail whose username and username ID is under your possession, could be said to be attributable directly to you, and therefore would be the electronically signed and e-document ratified under the IT Act. So our IT Act now has the two different signature styles, the digital signature and electronic signature, wherein the electronic signature is the genus, can include any secure means, even your Aadhaar authentication, even your biometric, even mobile phone OTP, if that is attributable to you, and also your email systems, including all other secure means. Whereas digital signature means only the PKI-based infrastructure system, of the governance of which have been dealt very well under the IT Act. Now, the second part of our 5 point something was defining cyber privacy. Now, Ms. Sonal has dealt very well about your data protection thing, but I will also deal about the cyber privacy and what your law, the IT Act 2000, talks about the cyber privacy. Now, cyber privacy here could be or could be said to be the different face of the same coin which deals with the data. If the data is the subject, then there could be said to be the two faces of that coin. The one is cyber privacy and the another one is the data protection. The data protection is in relation with the companies, whereas cyber privacy is in relation with the personal life and also is attributable towards the constitution, constitutional agencies and otherwise. So what about the cyber privacy? How cyber privacy has been taken up and defined? Whereas the cyber privacy could be said to be of the three types, the informational, communication, and the individual privacy, and have been dealt under the section 66 capital E of IT Act. It provides these many privacy subjects, like the data could be informational, communicational, your chat, audio, video, visual, आपकी files, activity based, location search, other device based, and identity and biometric. Now, all these things you could find out easily opening your settings.
I think we have lost him again.
Yeah, I guess there's some network glitch.
I think we have lost him again.
He's connecting it. I'll just check.
Yeah. Hello guys. So there is some network issue. So the speakers are gonna join soon within a minute or two. Hello guys. So there is some network issue. So yeah, just let's wait for 1 or 2 minutes. So by then, if you are having any questions, do post in the comments of comment section so that I can ask the speakers to address those questions. So we are just waiting for 1 or 2 minutes more. So Abhinav got a network issue at his end. So just let's wait for 1 minute for him. Yeah, so the session was very fruitful for me. I know there were a lot of discussion about various laws in India regarding US and UK, and about data protection bill of India 2019. Various key points were given from that. Also, a lot of things were shared. Just waiting for the speaker to join. Yeah, guys. So do post your questions in the comments so that I can take up those questions. Yeah. Abhinav is having some network issues, so he is gonna join in a minute or two. So by then, if you are having any questions, so please do comment in the comment section or post it in the comment section so that I can take them at the end. Okay, so by the time Abhinav connects back, let me give an update about tomorrow's session. So tomorrow we are having a session on how to be a first responder. So you might have seen a lot of yesterday we celebrated mental health day, and a lot of stuff was there online. You might have seen already in your social media. So how to be first responder on that? Suppose you or your friend is a victim of any of the cyber crime, so how should you as a friend or you as a victim should respond to those cyber crimes? So a detailed discussion about on that will be dealt tomorrow. And next thing is on 13th, Tuesday, we are having session on online frauds and safety measures. So various online frauds, all the online frauds happening and what safety measures you should follow. We are gonna talk on that. And next is online dating frauds. What all, there are many dating apps in this lockdown which have become quite famous. So various dating apps, and what all safety measures should be followed on them. And then we have a cyber safety workshop by Rohit Date, who is an offensive security certified professional, and other lawyers who will be talking on. It's a full day workshop. In first half, the morning session we have totally technical, so technical details will be discussed. And in the evening we are gonna have on law aspects of the session. And then we have crime diaries by my favorite Amit Dubey sir, who is an author for the book Hidden Files and a national cybersecurity expert. So you're gonna just amazing. It's gonna be just amazing. You're just gonna love it. And then we have AI laws, artificial intelligence laws by Abhivardhan Israel. And then internet shutdown, legal aspects, and then we have also mental health awareness session, various policies which you see in the social media, a discussion on that we have, and also for children in India we have something known as POXO Act. Okay, so how to, a platform is made by them known as POXO ebox. So a detailed discussion on that will be discussed tomorrow on 26th of this month. And then we have positive stories, because internet, all this whole month we have discussed various stories that internet in this is happening, this is bad happening, all those things. So we just want to have something from the internet that yeah, Abhinav, are there? Can you please speak? So we can't hear you. Abhinav, if you are connected, please do speak. Yeah, so various positive stories by various Instagram influencers or online platform influencers, because their journey, whoever has started their journey on this social platform using internet, whoever has is has built their career. So a detailed discussion on that is gonna be shared on the last week. And also we are coming up with a special week which is Digital Health Awareness Week. So now all of you are using your devices, school children are using phones and all. So what, a lot of story about how to take care of your health when you're using these digital devices. And now I'm using multiple devices. I have a phone, I have a system, I'm sitting 24/7 in front of them. So what all things you should take care if you are a child, if you are a pregnant lady, or a lot of such things affect us. How much, there is a radiation thing that comes out in that. So a lot of things about that we're going to share in that 1 week digital health campaign. So I think it has, on screen time, it is on physiotherapy, what all, rotating your head, all those physical exercise what you should be doing. And yeah, so how much screen time and what all measures. I think, one thing I use is when I'm using much, so I use this glasses which are UV protected or Blu-ray protected glasses. So these kind of things. So yeah, so just waiting for the speaker to join. Yeah, so regarding campaign also, if you're having any questions, please do post. So let's have a one-to-one live session now with me, so that I can answer your questions till the speaker joins and we are back with this in the session. Yeah.
Hello.
Yes, sir.
Yeah, I have connected him via the audio call, so you'll be hearing his voice now, okay?
Okay, hi. Am I audible?
Yes.
Yeah, you're audible.
Okay,
Hmm.
okay. So I'm really sorry for the connection drop. Now the network problem is such that it's not getting connected back. So what I will do, I will give you the short snapshot of those points, and I think Ms. Sonal would show you, guide you towards the PPT. So see, the first point was about the ecosystem, wherein I dealt with the difference between um,
digital signature and e-signature, electronic signature. Now, because of this, our law has the two different kind of sets of signature, wherein one is electronic signature, which is set to be digital, and the cities of it, which came earlier actually, but still it is actually the city which is digital signature. Now, the second problem I was dealing with was about defining cyber privacy. The Indian government could not comprehend the idea of the informational privacy, communicational privacy, chat video, file, activity-based privacy, which you mostly now use in your smartphone. And with the updated version of the Android 10.0 and 9.0, you would find out that your smartphone each time asks you if any of such privacy, your private detail is being taken by any app or any website, which includes search-based activity, location-based activity, any file or other activity, visual, audio, chat, communication, reading capability, and informational privacy, your name and other ones, or by identity-based biometric services. The Indian IT Act, Section 66, capital E says that any capturing of the image of private area of any person would be the privacy. The idea of cyber privacy into the Cyber Act, the IT Act of India, just talks about the private area of any person. Whereas, if it is about pornography, then IT Act already has three different sections about the pornographic content. One is about cyber obscenity, another is about disseminating cyber pornographic content on cyber world, and third is about disseminating cyber pornographic content involving children, so means child pornography. So three different sections deal with the private parts of the people, and that those are not enough. The government created another 66 capital E, wherein it involves the publishing and transmission of any private area images of people. So you may laugh out loud, but still, the way is forward. We have seen a good amount of description provided by Ms. Sonal about the data protection law, and that is coming very soon to deal with the whole privacy and data protection issue. Ultrasonic case also has put your privacy matter into a constitutional framework, or rather I should say that in the fundamental rights framework, wherein the part 3 of the Constitution now deals with your privacy. So the privacy, the aspect of privacy has become the constitutional privacy. Thank you. So I just deal with the next point, the intermediary liability. Now, the Indian IT Act also deals with the intermediary liability concept here, which US uses in Digital Millennium Copyright Act, wherein they use it into the Copyright Act. We use it in the IT Act. The IT Act says that the intermediary liability means that any intermediary which is in the between of any end consumer and the content creator would not be considered criminal per se if they are making use of any security practices and all reasonable security practices, which Ms. Sonal talked about, that there is also a rule about the intermediary using the reasonable security practices. So given this, in the same rule are the reasonable security practices which are to be used by the intermediaries, and if the intermediaries are using those reasonable security practices, they could not be said to be liable, given the conditions are that if they are not maintaining any content over, they are not controlling any content over. For example, content over ki baat I would take the famous case of Napster and the Blockbuster later on. In US, during the 90s, when the music CDs, digital music MP3 file sharing was very prevalent onto the computer and computer network, one guy, I forgot the name, created Napster software, which used to take the music files of the people from the computer, of course by their consent, and upload it onto the server and then distribute it among the network, जो उसका network join कर. But this was a kind of a piracy, wherein the music was being, pirated to the another person's computer, wherein the one person has bought the music file. So the music company brought in case against him, and it was successful because it was found that his company, Napster, was actually dealing with the music files directly while keeping them and storing them onto their server because they were saving the files on their server. Afterwards, another person created Grokster onto the same idea of the Napster, just removing the middleman of the server owner. And they created a distributed network of the people who can share music files among themselves. Just like torrent. Just like torrent, the people were now using the service and also sharing the file among them. So the people became the culprit, and Grokster was again prosecuted by the music companies, the big companies, but they could not succeed because of the reason that there was no intermediary concept. He was just said to be a creator of a software. He was just said to be an intermediary, wherein he was not involved in maintaining and dealing with the content of the music file because he was not saving it onto their server. Simple enough. So that is the same concept of the intermediary liability added with some conditions and upgraded over. So the intermediary liability concept, which is highly used in the copyright and the other IPR laws, is there in our IP Act already. Now, coming to the fourth point, which talks about which critical information infrastructure protection. So what is the critical information infrastructure protection and how is it related to the cyber security? So you might have seen that, you might have heard that Ms. Sonal talked about one concept of the protected system, and also she dealt about one IPS rule relating to the protected system. The definition of the protected system actually says that Government of India have the authority to nominate certain computers as protected systems which are dealing with any information on infrastructure services which could have debilitating impact onto the country and country's economy if tampered with. If those services would be tampered with, if those infrastructure and information computer system data have been tampered with, they would have the debilitating impact on the country's growth. So these kind of services have been said to be under the critical infrastructure. Critical infrastructure, very important. For example, the critical infrastructure could be anything: railways, roadways, water, even your phone line and hotline and internet. So now internet and information infrastructure has taken a shape of being a critical infrastructure. So when we talk about the cyberspace, it becomes critical information infrastructure. And the protection is one thing of it, which is a facet of cyber security here. So India already have one cyber security provision starting from 2005. It came by way of the amendment 2005, and we have. But how we are using it is the problem. The Indian government did not take any heed to create the nodal agency of the Critical Information Infrastructure Protection Agency till the time of the 2018. In 2017-18, they created a nodal agency which is still unknown to the people. People do not know about the NCPAC, National Critical Information Infrastructure Protection Agency, and what work it does is still unclear in 2020 to the people. And wherein even if the agency is working, it is not clear because the government has been given authority to nominate any computer to be named the CII, but government has not declared certain computers to be the protected computers. That is the problem. One case is there, but which is very peculiar case, and you will be amazed to know that the case came under critical information infrastructure protection, but not due to being a protected system, not due to being a cyber security matter, but due to being an IPR facade between the government and one company who created the software for government. So I guess it is the case of the Karnataka government, wherein the Karnataka government asked one software company to create a software which was related to the providing government services, which means e-governance. So that e-governance software was used on a trial basis with the government. Later on, that company asked for some royalty and money for that software. The government said that no, they were using it for trial, but now it has become the part of it and they won't pay even money. So that company took charges of the IPR against the Karnataka government. Then government declared the same system being protected system under the same section 79 of the CII, section 70 of the CII, wherein they said declared it being a protected system, so no one can touch this system. Now, a case was taken against them being a protected system. The Karnataka High Court could not do anything and could only say that wherein ITX has this provision of declaring any system being a protected, the government's intention could not be questioned in, and the system would be declared to be protected, and therefore the system would be added. So you could see that one also private company created for e-governance practice, but they created software, so they were the kind of owner of the software, and government stopped them from being owner and took their IP and converted it into the critical information system, protected system. So they tried to hide one unlawful activity into the another lawful activity, wherein the law gives them authority to do so. But for the really important critical information infrastructure, which was really very important, they could never do so. The government failed to declare all those important systems, for example, which were dealing with the sensitive personal data. Like Aadhaar was also declared very later stage. At very later stage, it was declared to be the protected system under the CII provision. The government should now, become a bit progressive and start using the CII provisions and other cyber terrorism provisions which are there already in the ITS and use them accordingly to safeguard the people and also mark a new step into the cyber security. When we do not, we do need cyber security law, we do need the revisions of the cyber security policy and the provisions, but still, to some extent, we can make use of the given provisions for a better enforcement so that we don't feel lagging behind. Thank you. Thus, I submit this presentation to you guys. Although I had certain more PPTs, but I guess the time is also over. And sorry for the connectivity problem. Now I will be ready to take in the answer session along with the help of Mr. Thank you.
Yeah, thank you so much, Sonal and Abhi, for taking this amazing thing for us. It was very insightful. So very few questions we had. What are there was a question, what are major differences which we see? I think this is already covered, but if it's upon you again, so what are the major differences that you see between Indian and international laws?
Can you just repeat the question again?
Yeah, what are the major differences that you see between Indian and international laws?
Just a second, hold on.
Yeah, we are back with Abhinav.
Yes. So now I'm back. Thank you.
Yeah. So Abhinav, do you want to comment on this? What are the major differences in Indian and international laws, cyber security laws, cybercrime laws?
Okay. So as you can see that I discussed about the evolution of the Indian and other certain US and UK laws, the cyber laws. So it is actually based on to the e-commerce initiative taken on by the Ancestral Model Law, and we have adopted the same Ancestral Model Law, only accepting incorporating the Indian changes which were required. That is why in 2005 a major amendment came in, which actually implemented the loopholes, which actually addressed the loopholes, but still a lot many to go on. If you want to want me to discuss certain more international agreements, then We don't have that cyber convention, but apart from that, we have in United Nations treaties, United Nations Convention against transnational organized crime, which came in
Mm-hmm.
2000, which is also known as the Palermo Convention, which obliges state parties to enact domestic criminal offenses that targets organized criminal groups. And since these organized criminal groups also make use of the cyber space at a large scale, so it created the framework for extradition, mutual legal assistance, and law enforcement, wherein it also helped about the cyber crimes and cyber means to tackle the cyber crime for the countries. So it is also highly relevant. Apart from that, CRC, the Convention on Rights of Child, which came in 1989, also deals about the Article 34 deals about the obligation of state parties to protect children from all form of the sexual exploitation. And as I discussed, that our IT Act also deals with the cyber pornography, which
Mm-hmm.
was also in given in the optional protocol of the convention of CRC, same which came around 2001. Now, apart from that, the robust system of the international cybercrime is only given in the regional area of the Europe, wherein the Council of Europe has the certain treaties. But I would say that the international law, the international regional law of the Europe is more like the domestic law, which governs the EU countries or the EU prefecture at large. So that is
Mm-hmm.
why I am not sure that should I keep it into the. Of course, it should be kept into the international area, but the convention, which is called convention, is more often taken like the domestic laws, because the Council of Europe implements them into the same manner as it should be implemented by the state parties. For example, the GDPR, and it
Mm-hmm.
becomes prevalent to the whole of the Europe as it is. That is the reason I'm saying that of course it's a regional international law, but it is taken back like more as domestic law. So the important conventions would be the Convention on Cybercrime, which came in 2001, known as the Budapest Convention, which is even said to be the first international agreement reducing the computer-related crime by harmonizing the national laws of the Europe as a whole and improving investigating techniques and increasing the cooperation among the European countries. उसके बाद में then came the additional protocols to the cybercrime, which were about the xenophobic nature, um, racist and xenophobic content prevailing over the cyberspace को वो deal करता था. And then afterward the same one convention came about the just like CRC, they created a convention on protection of children against sexual offenses and sexual exploitation, which includes the cyber pornography. Because if there is one thing onto which the whole world is unanimous and unified, that is about the cyber pornography, wherein the most of the country has legalized the pornography and porn channels, so they even want to stop the child pornography. So I guess that would be it.
Mm-hmm. Yeah, that's amazing. That's amazing. Thank you so much, Abhinav, for that clear differences between a
Thank you.
lot of stuff. So
Thank you.
we are having many more questions, but as we are running out of time, so I would
Yes.
request everyone to please email to us or write us in the chat so that we can send it forward to Abhinav and let you know the response. Thank you so much, Abhinav, from the board
Thank
of
you for
Cyber
this amazing
Jagrithi, and on behalf of the Cyber Vakeel team and the board of Cyber Jagrithi Foundation. I thank Sonal Saxena ji and Mr. Abhinav K. Mishra ji for spending
Thank
this
you.
time with us and letting us know, on Indian versus international laws. Thank you so much.
Thank you. The time was less, but it was a
Thank you
very
so much.
wonderful opportunity.